Hi, and welcome to Interviewed by a Parent. Today we're talking to Scott Adams about financial planning for children with special needs. Scott, how did you get into financial planning for children with special needs?
I like to say it was some great business plan or a brilliant mind on my part, but it really wasn't. I found a wonderful woman who is graduating from the University of Kansas with her doctorate in autism, and we decided that we needed to adopt a child with special needs. That's my oldest boy now. He's now 10, and he also had a brother and a sister which we adopted at the same time. A year later, we got the diagnosis that both of them have severe special needs. From that, we really tried to do our own planning, and with my wife's background as a doctorate in autism, and I taught certified financial planning classes, and I'm actually a certified financial planner myself, we thought we'd done it correctly. Unfortunately, by having some very good friends of mine walk us through what we had, it wasn't appropriate and it wasn't even correct. So that's really what started us down this road of creating a place for families where they could get correct answers to make sure that their children would be safe.
Can you tell the audience more why it really is important and what you found out over the years?
I'd love to, Gerard. Gerard, the issues that we face and our kids face in many instances are unique to having a child with special needs. We've always orchestrated their needs up until age 18, and at that point they are themselves. They have to have their own benefits, they have to have their own lives, and legally their world changes. And as parents, we are their best and sometimes only advocate, and we need to understand the rules of the game. You can't win a game if you don't know the rules, and our children are the ones that are dependent upon us. The main thing that we want to make sure is that we have a blueprint, so if something happens to mom and dad, that the rest of the children in the family and the child who has special needs, make sure that there's a blueprint which will continue and they'll be able to conduct their lives as normally as possible. I think sometimes we don't realize how many of us there are out there. In the state of Kansas alone, we know 1 out of 9 families has an IEP. And I always relate it to when you buy a car. If you buy a new gray Honda and drive it off the lot, we all of a sudden realize how many gray Hondas there are out there. So as a parent with children with special needs, we are definitely not alone, and there's lots of us driving gray Hondas out there. I want to make sure that every parent can answer 3 main questions. The first of which is, at age 18, in order to qualify for Social Security, how much can your child have in the way of assets? The federal guideline is $2,000. Now each state can lower that minimum based on what their legislation has done. We have some states that it's only $1,000. So please make sure that if you're leaving assets to your children, it's less than $2,000, or you're going to have to do it in a different way. The second question we've got is transitioning. If mom and dad don't come home some night, does the court have something in writing that they understand in their language that dictates where your children will go? This also counts if you have guardianship over a child over the age of 18. There must be a directive that tells the courts how you want your children raised. If it is not there, the courts will actually decide for you, meaning they're going to line up all the people that love your child or don't love your child, because a lot of times there are assets associated with it. And the court, he or she, is going to make the determination. We have a moral obligation as a parent to make sure that we take that into our own hands and make those decisions. The third is, at age 18, your access to information is going to end. When your child turns 18, they become age of majority in most states. In some, it's 19. At that point, if you want to attend an IEP meeting, you want to go to the hospital with your child or attend a doctor's appointment, you have to have permission. We need to make sure there's some documents in place at the age of 18 which will allow you to do this. There are legal and financial issues that are very complex and very unique to our children. It is not easy to go through these questions. It's like playing a game of chess. Those of us who've been playing for many years understand the strategies and the rules. If you don't know the rules and you don't know the strategies, there's absolutely no way you can win the game. The same thing with taking on the Social Security Administration or an IEP meeting or anything else with our children. If you don't know the rules, you cannot expect to win. That's why these rules are constantly changing, which means you have to stay up to date to be the best advocate for your child. There are 3 main legal areas that we need to be aware of: wills, trusts, and at age 18, what documents will give us access to information. The first of these is wills. A will has 2 main points. As a recovering analytic, I've broken it down into 2 very simple points. The first thing that it does is it tells people where my stuff goes. That could be a car, 401ks, houses, anything that you have. And the second, and most important, is where do my children go? So a will has 2 primary functions. Where's my stuff go? And where do my children go? Without a will, the courts don't have the direction, and they will be making those decisions for you. The second is a trust. Unfortunately, with our children, if they have special needs, it is imperative that we use a vehicle called a trust. I tell the story of my son. He's now 10, and he has a habit of bouncing up and down. He makes Michael Jordan, gives him a good run for his money. But if I stack his school books in his hands and a peanut butter and jelly sandwich in his lunch and send him out the driveway with him bouncing, I'm going to find that I have 3 dogs, well over 300 pounds total, an English Mastiff, a Lab, and some others, going against 60 pounds of my son. Now the chances of the peanut butter and jelly sandwich getting to the bottom of our hill is absolutely 0. In order to change that, I have to put it into a backpack, hopefully with a clasp in the middle that he can't undo. Now, the trust is the same thing as the backpack, meaning the sandwiches will probably get to the bottom of the hill. My dogs may have drugged my son to the bottom of the hill at that time, but they should get there in some way, shape, or form. It is not a perfect methodology, but that's the best we have, and that is what a trust is. It's no more than a backpack. And sometimes I think we get caught up in the legal languages or the confusing words that we don't understand, when the simplest way to say it is, if you have stuff that you want to leave to your child who has special needs, we have to do it in a way that the courts understand, and that is with a trust. The next issue we face is at age 18, our children actually become legal adults, or 19 in some states. This means we lose access to information. One of the things we try to get parents to understand is we as parents should have a couple of documents ourselves. They're called durable powers. If I'm incapacitated and I would like my wife to be able to make decisions for me about my medical care, I need to have a durable power of attorney for health care appointed. Each one is state specific. Please do not download them off the internet if they're not your state. The other one is a power of attorney which allows her to have access to my financial records, meaning if we need access to my 401k or she wants to get money out of our home since I'm not working and incapacitated, she has to have my signature. Without a legal document that says she can sign my name, she can't access any of those things. Now the next issue we have is, how does that apply to my son? In order for me to grant someone the power or a durable power, I must understand what I am granting them. If our children are not able to communicate that or understand those powers, they are not able to use a durable power. If that's the case, then guardianship is more appropriate. This is the way of extending the rights that we have under the age of 18 past 18. It requires us going to court, and it requires us having people come and interview our children. There are lots of different types of guardianships. There are limited guardianships, there's full guardianships, and each one has its own strengths and weaknesses. Please do not run out and get guardianship. Each child and each family situation is uniquely different. Make sure that it is appropriate for your child. Each state's rules and regs are different, and make sure that you understand them before you do that. Taking guardianship is a major step in the life of your child. Guardianship also can be revoked or repealed at some time. It is not permanent. So if something happens or the child is cured or develops to the point where we feel that they're able to make medical and financial decisions for themselves, it might be prudent for us to remove the guardianship. That leads us into the next conversation with guardianship. Usually we have a conversation with someone who is going to be the guardian, whether our children are under the age of 18 or over 18. What we generally do is we have a nice meal. We go out and we get whatever they like to eat. We'll have a large amount of desserts. And at the end of dinner, my wife and I actually did something called a full court press. We both lean forward and we ask the question, would you be our children's guardian? Now, we've had a wonderful meal. We've had a great discussion, and we've really backed this couple into a corner where they can't say no. That's not very fair. In our home, we have horses. We have horses because we do hippotherapy. We have a swimming pool because we have to do crossing skills for a brain injury. We have lots of appointments and lots of therapy. We didn't discuss any of this over dinner. So what we have is a couple that has said yes, they're going to be our guardians, but they have no idea if both of them have to work or if they have to stay home. They don't have any idea what the medical needs of our children are, nor do we know if their children and our children will be able to interact on a safe basis. That is not the best way to have the conversation. Instead, I think it makes sense to create an instruction manual for each one of our children. We call it a continuity of care plan. This plan allows us to put in writing all of the things that the next person is going to need to know in order for them to take care of our children. All of our children have idiosyncrasies. Many of our children have set schedules. When the schedule doesn't come off the way that it was meant to, It can lead to behavior issues. It can lead to our children not being happy or not being as fulfilled. We need to put that down in writing, because if mom and dad don't come home, all that information doesn't come home with them. My daughter doesn't like riding on the right-hand side of the car. Where is that written down? How are you going to know that? We have a medicine cabinet that looks like Walgreens. If the next guardian came in and didn't have any idea what we were doing, they'd have to basically wade through all of that and try to make the best they can of it. I don't think it's fair for us to make our children educate another adult. It's taken mine 5 years to get it into dad of how they want to be treated and what makes them tick. Not putting that in writing is not fair for them, and that is not fair for the guardians. Now let's go back to that dinner. If all of a sudden we have a manual, so to speak, an instruction manual or blueprint for each child, we still have the dinner, but at the end of dinner and at the end of dessert, we go through each one of the manuals. We ask the couple to take them home, review them, call us with questions, and then make a decision. They can pray about it, do whatever is appropriate for them, and then call us back. We do ask within 3 to 4 days to get a call back, because in the meantime, we're going to be sweating like bullets. It's that fear we have that they'll say no. And that is driven by, many times, most of us only have one couple or one family member that's going to be able to do this. But it is not fair for us to back them into a corner. We must give them appropriate information and accurate information on each of our children so that they can make an educated decision as to what is best for them and their family. If we force them into a corner and our children don't work in their family unit, we've really created the same problem for them. We could actually devastate their marriage. We could actually have our children going back to the courts or where they came from, which is not the intent. So by doing it correctly the first time, again, there are no guarantees in life, but it's a much better way for us to ensure that our children will have a quality of life that mom and dad want to have. The issue with that is really with a blueprint, you can hand it to the next person or they can hand it to someone else. We recommend you do this through internet or you do it on WordPerfect. That way, as therapies change, medications change, needs and wants change, you can keep the guardian up to date. This does two things. One, instead of just having a nice conversation, they said yes, they're actually getting an email occasionally, which means that you're dead serious. It also allows them to have accurate information that unfortunately, if mom and dad don't come home that day, they already have the blueprint in their home that they can print off or read and make sure that they know what's going on. If you don't have one of these done for each of your children, I would highly recommend that you compile one. The next issue we have is trying to get accurate information. As parents, we get lots of information from lots of sources, and we're usually confused because it sometimes conflicts each other. I want to make sure that you understand that the professionals that we work with must be trained because what we do is unique. In law school, we have as yet to find one that teaches just special needs planning. We're working on it. As a part of the elder care, we see it, but there isn't a specific degree in that. One of the stories I like telling is of Teresa Varnett, who actually went out looking for a law firm to do the legal work for her daughter, and she didn't find anyone who could do it. So her simple solution to the issue was a 3-year solution, which was to go to law school. The second year of law school she attended, she asked, when are we going to start studying special needs? And the law school said, no firm is going to hire you at a competitive salary, so we don't teach that. I think we have to understand that everything that we do is economically based. We have to make sure that law firms understand that they can have people focus on us. Teresa now has 3 large practices and is a strong advocate for us on Capitol Hill and is a wonderful parent and is a great speaker if you ever get the chance. But they are taught most of the time in law school 3 ways to plan for our children. Number 1, it is to disinherit our children. Meaning, if we keep them below that $2,000 magic number, they will qualify for benefits. However, if they're in a group home and they're not working or they can't work in a workshop, they will be living on somewhere around $28 to $30 a month. Each state's different, but it's not going to be much more than that. I know most of your children enjoy movies and reading books and doing computers and going out to lunch and those things. And if I put $28 into each one of your children's pockets or yours, I don't think it lasts much more than past the next day. So I think we can do away with disinheriting. The next one we see an enormous amount of is called morally obligated gifting. This says that I'm going to leave all of my stuff to my 2 youngest daughters, who will then take care of their 3 siblings who have special needs. This puts an enormous amount of pressure on my daughters, and I've seen money make people do crazy things. Now, of course, all of our children are perfect, and we don't have to worry about that. But if my wife and I leave all of our stuff to our 2 youngest children, and one of them becomes divorced, half of my assets that are with that daughter will go to the son-in-law. Neither my daughter nor my son-in-law will have any legal obligation to take care of my 3 oldest children. At that point, all the money that I had set aside for my 3 oldest children will disappear. I don't think this is what we want. It also puts a child in the line of fire, meaning every time one of my 3 older children wants something, they have to ask the 2 younger. They really take on a parental role. If my youngest wants a pony, my children have to say no, or if he wants something else, you're constantly going to get the no, no, no. It can actually make a sibling act as a parent, and you can create resentment in that fact. So please think about who you want to have, what I call in the line of fire for the questions. And many of us have thought that leaving the sibling relationship alone and letting them be siblings and having Christmas dinner and the Thanksgiving and the Sunday dinners is extremely important for the contact for our children and not requiring a sibling to act as a parent. That gets us to a special needs trust. The best and only way to leave money to our children is called a special needs trust. Each state has different rules and regs. There's 2 main types. One is called a standalone special needs trust, which is actually funded today by mom and dad. And there's a testamentary special needs trust, which is funded at the death of both mom and dad. Each state is unique and different. We have seen in some states the standalone trust is being attacked. We as a firm have actually leaned more towards the testamentary side, which has held up in all 50 states and when they've been attacked by the courts. What these trusts do is they allow you to put anything that you want into them. You can put property, investments, homes, land, stocks, IRAs. Anything can go into the trust. But we have to remember the point of the trust is to enhance the quality of life for your child. It's a blank piece of paper. Don't get caught up in the legal language or what it is. You need to come up with the best idea of how to enhance the quality of life for your child. We actually have a family who bought season tickets, 4 of them, for their young boy who's now 35 years old. And he's living in a group home. It's a professional football team, and he gets to go to every single home game. He also gets to take a friend. This young man's done more dating than I ever did before I got married to my wife. But there's 2 other tickets that he gets to pick, and the trust indicates that he's the one that must pick them. It can't be the guardian, and it cannot be the trustee, because both of those are family members who love him. It actually stipulates that he has to pick staffing. And the staff is chosen for the explicit purpose of him getting better care. I'm not arguing if that's right or wrong, but I have 2 parents who are enormously creative with not a lot of money that said that if the staff is competing with each other for his attention and to go to these games with spending money in a parking pass, their son would get better care. And that is accurate. The other thing we found happened is every morning you can't pry the sports page out of this young man's hand. He enjoys reading. He hated reading before, and his reading comprehension has increased. He also can converse with any group of men, or women for that matter, in an appropriate fashion about sports, which is a very appropriate subject. Now, we're still working on him showing you his Chiefs Boxers, which is the popular team here. But the point of it is we've increased the quality of life for this young man enormously. We didn't leave a ton of money. We didn't leave a ton of land. We left 4 season tickets and a trust that was written appropriately by 2 parents who absolutely loved and adored their son. Again, you are your child's best advocate, and you know your child better than anyone else. It's up to you to create this in the way that's going to enhance the quality of life for your child. The one thing you need to be careful of, though, of placing assets into a trust is making sure you understand how they come out and how they're taxed. We could put anything into the trust. Another example of this is we have a gentleman who's been collecting baseball cards with his father for over 30 years. This gentleman has a diagnosis of autism. If you know anything about autism, you'd probably guess that he's not missing a single baseball card and they're in mint condition. These baseball cards are the way that he communicates the outside world. If we do not put them into the trust, they're going to have to be sold off when mom and dad pass away, because obviously this card collection is worth more than $2,000. By placing the cards in the trust, and he has absolutely no concept of what the trust is. If you ask him, he'll say, who owns the cards? And he'll say he does. But according to the Social Security Administration, the trust does, which means it keeps him below the $2,000 restriction. He gets to keep collecting cards, and he keeps his communication tool for the rest of the world. Again, we're not talking large sums of money in these trusts. We're talking about what the children need to keep their quality of life intact. The other issue we have is taxation, meaning if we pull money out of trusts or it's created in the trust, we need to understand Most of the people, just like attorneys, if you're working advisors, you need to have someone who is very competent in taxes. Trusts are taxed at $13,000 of income. It's a graduated scale, just like your ordinary income. However, at $13,000 or greater, there's a flat tax, currently at 35%. So if we put stocks or bonds or homes that have a capital basis, we're going to pay less in taxes, and it may be a better asset to have in it. Whereas if you have 401ks, IRAs, those types of issues, you could really be spending 35% of that in the way of taxes. Again, each person is unique, and each plan that you need to develop has its own characteristics. I'm not saying don't do it. What I'm saying is you need to be aware of the things that you put in it, and when they come out, how they are taxed. It might be better to leave the 401k and IRA to other children, if there are any, and put the tax-qualified assets in a different bucket than the special needs trust. Again, please rely on tax help and professional help in this matter, and don't try to go it alone yourself. The next issue we have is planning for our children is very different. Meaning most of the time mom and dad raise our kids, and at age at least, I think it's 40 now, they leave home. I'm not sure exactly when that is. But at some point, we are no longer financially responsible for their care. With many of our children with special needs, however, we not only have to fund our retirement, which we call the first retirement, we have a second retirement, which is after mom and dad are gone, we have to make sure there is funding available for our children so that their quality of life will continue. This is a very daunting task. It also requires more in the way of savings or more creative ways of putting money into trusts than other people require. Again, something that most people haven't even thought of, let alone have planned for. The Special Needs Trust allows you to put whatever that you feel your child will need to increase their quality of life in this for their protection, and they will remain on SSI and for the benefits. In summary, what I'm trying to get you to understand is that planning for your child with special needs is very unique. It requires people with very specific skills. A couple of questions for the law firm I'd like you to ask. Number one, how many special needs trusts have you done in the last 6 months? Not just regular trusts. You need to make sure that you articulate special needs trusts. If it's less than 6 or 10, I'm not sure that that's going to be a good decision for you to go with. From the standpoint of, if a law firm does a lot of this type of work and it provides that firm a fairly decent amount of their revenue, they're going to stay current on the issues. They're going to invest in continuing ed, and they're going to be involved with our families. If they are not involved and they don't stay up to date, which is the next question you're going to ask them is, how do you stay current? How do you stay up to date on legislative changes? We need to make sure that the firms that we trust are actually involved and stay up to date. If they don't, in 5, 10, 15 years, your trust may not work and your child will be at risk again. And the third issue, which is not imperative, but I've always found that it helps, is do they have a heart for our kids and for our families? Do they truly understand? And what I look for here is, are they involved in boards or not-for-profits, or do they coach, or are they involved with us in any way? Again, that's not something that's actually imperative, but I've found that it really helps them with the follow-through and making sure they're taking care of our families. And the last part of that is making sure you're working with tax advisors or financial planners who absolutely understand special needs planning. Make sure you ask them the same questions. How many families like ours have you worked with? Ask them about the trust and how they're taxed. You'll be amazed at how many people don't have any idea how that works. And if they don't understand, you're putting your child at risk. Because at the end of the day, what we're trying to accomplish is making sure that when we're no longer here and our children are left, that they have a quality of life that's been enhanced and maintained, and they live the life that they can to the fullest and best extent that they can. I want to thank you for your time, and please direct any questions you've got to our website, which is www.specialneedskc.com, and we promise we'll answer them as quickly as we can.
Scott, thank you for talking with us today and teaching us so much about this topic. I think it's important to all of us as parents. If you'd like to know more about this product or some of the other products we offer, visit our website at thegiftedlearningproject.org or theglp.org.